Hello, I'm Floyd Stokes, your HA2 Introduction to Law Enforcement instructor at College of the Redwoods. Today I'm going to discuss Chapter 11, Civil Liability and Accountability. This chapter has three learning objectives. 1. Identify the two main avenues available to aggrieved parties seeking to sue the police for civil liability, and list some of the defenses against civil liability that law enforcement officers, their supervisors, and the department might employ. 2. List and explain 5 external measures other than litigation for promoting police accountability. And 3. Discuss procedures for promoting accountability from within police agencies. All right, let's get started. One of the core principles of the democratic system of government is public accountability. Following a series of scandals, administrators with the Los Angeles Police Department entered a consent decree through the federal courts in 2000 and undertook a number of efforts to improve policing in the city. The decree followed what some called a decade of policing crises that began with the Rodney King beating in 1991 and culminated with the Rampart subdivision scandal of 1999. Today, the Los Angeles Police Department is reportedly completing one of the most ambitious experiments in police reform ever attempted in an American city. First off, whenever a person's constitutional or other federal rights are violated, a lawsuit can be filed, even if a person merely believes that his or her rights have been violated. Litigation is still an option. Litigation is also an option for tort violations or civil wrongs that do not rise to the level of a constitutional rights violation. Lawsuits in which people seek monetary compensation are called damages suits, and the money paid is called damages. In addition to damages, plaintiffs can seek injunctive relief, which means that the plaintiff wants the court to bring the injurious or offensive action to a halt. 42 U.S. Code Section 1983 is the federal statute that provides a remedy in federal court for the deprivation of any rights that are secured by the Constitution and the laws of the United States. Color of law. Requirement for a successful Section 1983 lawsuit is that the defendant, that's the person being sued, must have acted under the color of law. Someone acts under color of law when he or she acts in an official government capacity and with the appearance of legal power. Constitutional violation. A second requirement for a successful Section 1983 lawsuit is that a federal or constitutional rights violation must have taken place. In determining whether a constitutional rights violation has taken place, the plaintiff, or the suing party, must establish that the conduct of the defendant or defendants violated a specific constitutional provision, such as the Fourth Amendment's prohibition against unreasonable searches and seizures. Recently, the courts have begun to require that constitutional rights violations alleged under Section 1983 be committed with a certain level of culpability. That is, plaintiffs generally have to prove that the defendant officer intended for the violation to occur. The term theories of liability refers essentially to reasons offered as to why a particular person or entity should be held answerable under civil law for some action. A typical Section 1983 lawsuit will target an individual officer, the officer's supervisor, the city or municipality for which the officer works, or some combination of these. It is often attractive for plaintiffs to go after bigger fish because that is where the money is. In other words, going after cities and counties that have deeper pockets. Suing federal officials. Before 1971, it was not clear whether federal officials could be sued under Section 1983. In the 1971 case, Bivens versus 6 unknown named agents, however, the U.S. Supreme Court held that federal officers can be sued for Fourth Amendment violations. Bivens' claims are primarily limited to law enforcement officers. Certain federal officials, such as judges and prosecutors, cannot be sued under any circumstances, meaning that they enjoy absolute immunity. Qualified immunity is a judicially created liability defense that shields a police officer who has acted in an objectively reasonable fashion, even though a lapse of judgment or an honest mistake occurred. A state tort claim is an important avenue of redress for plaintiffs whose minor injuries, allegedly resulting from negligent acts or misconduct by the police, are not serious enough to make Section 1983 litigation a viable option. There are two types of state tort claims: an intentional tort, where a defendant officer knowingly engaged in behavior, and a negligence tort. The mental state of the defendant officer is really not at issue. There are 5 defenses: public duty doctrine, that's police protection that is owed to the general public, not to individuals. Contributory negligence. If the plaintiff was also negligent, the officer is not liable. Comparative negligence. This issue looks at who is to blame and assigns liability accordingly. Assumption of risk. Plaintiff voluntarily engaged in dangerous activity, so the officer is not liable. And finally, sudden peril, a situation in which the officer was required to make a split-second decision. Lawsuits serve as a powerful check on police misconduct. The problem, however, is that litigation is not always a viable or desirable alternative. Other measures have been put in place to pick up where litigation leaves off. Debate over external measures of accountability. Some say that the departmental administration has the best potential for efficient, effective action to prevent, investigate, and punish police misconduct. But others feel external review is critical, arguing that true control occurs only when civilians have primary responsibility for investigating misconduct. There are 3 distinct models of citizen oversight. Civilian input, and in this model, civilians receive and investigate complaints, but the next steps are taken by the police department. Civilian monitor. This model is similar to an ombudsman approach in which the complaints are received by the police department, and the process from beginning to end is monitored by civilians. And 3, civilian review. In this model, a group of citizens investigates complaints against the police, adjudicates the complaints, and recommends punishment. In general, citizen oversight is concerned with investigations of police misconduct, including investigations of citizens' complaints. Citizens' complaints are documents filed by people who feel they have been wronged by one or more police officers in a department. Citizens' complaints are sometimes seen by administrators as, to quote, a barometer of police performance, unquote. Complaints can indicate how officers are behaving on the street, which is useful because police officers are not always supervised by their superiors. Agencies should not have to rely on complaints to understand how they were doing, but complaints can often send important messages that would not otherwise be clear. Agency accreditation. Accreditation refers to certification for having met all applicable requirements put in place by an accrediting body. Simply stated, it amounts to credibility. Accreditation is a big issue in the academic world. Accreditation has spilled over into law enforcement as well. It is a process intended to ensure that agencies remain accountable to the public and that they abide by the highest standards of conduct in the field. The Commission on Accreditation for Law Enforcement Agencies, otherwise known as CALEA, was established in 1979 by the International Association of Chiefs of Police, known as IACP, and other national executive organizations with these objectives in mind: to increase the ability of law enforcement to prevent and control crime, to increase effectiveness and efficiency in the delivery of services, to increase cooperation and coordination with other agencies, and to increase citizen and employee confidence in the agency. Another important mechanism of ensuring the accountability of police agencies is the exclusionary rule. The exclusionary rule mandates that evidence obtained in violation of the U.S. Constitution cannot be admitted in a criminal trial to prove guilt. The so-called fruit of the poisonous tree doctrine has expanded the scope of the exclusionary rule. This doctrine requires the exclusion of any secondary evidence, such as a confession, that derives from evidence originally obtained in violation of the U.S. Constitution. For example, if a police officer was to illegally arrest someone, any evidence obtained as a result of that illegal arrest would be excluded at trial. The most common federal statute used to hold police officers criminally liable for depriving someone of his or her civil rights is U.S. Code Title 18, Section 242. To be held liable under Section 242, a law enforcement officer, state or federal, must act with specific intent to deprive a person of important constitutional or other federal rights. Occasionally you hear or read about news accounts of criminal behavior by law enforcement officers. No one is above the law, not even police officers. However, when officers break the law in order to protect the innocent or to prevent some greater harm, they can claim a, quote, law enforcement, unquote, or public duty defense. The public duty defense is meant to shield police officers from criminal liability when they act reasonably in such situation that results in the use of force in effecting an arrest, but is later accused of assault by the person arrested. The preceding section may give the impression that there is something wrong with internal accountability mechanisms, the organizational steps that police departments take to address wrongdoing. Nothing could be further from the truth. Internal affairs divisions and codes of ethics are effective measures for promoting the accountability of those charged with serving the public. Internal affairs is essentially an investigative agency with a police department, actually within a police department. Internal Affairs investigates allegations of misconduct or criminal behavior by law enforcement personnel. Internal investigation units receive complaints that are filed in various manners, either verbally or in writing, openly or anonymously, by civilians or sworn police officers, in person or by telephone or by any other means. Complaints must be investigated regardless of the manner of filing or the type of incident involved. Employee rights are a complex topic and are really beyond the scope of this discussion. However, it is important to note that a number of court cases have addressed the issue of police officers' rights during the course of internal affairs investigations, including the 1967 case Garrity v. New Jersey, and the 1985 Supreme Court case Liability versus the City of Los Angeles, which dealt with the issue of administrative disciplinary action for insubordination if the employee refused to answer questions. To reduce the temptation for internal investigators to proceed against police employees in an insensitive fashion, police officers' Bill of Rights have been incorporated in the laws of the states, or into labor contracts or agency policies. These rights include such issues as the requirement for advance notice of an investigation, due process, reasonable protection from inappropriate investigative practices, and fair and appropriate treatment by the IA investigators. Another mechanism for promoting accountability from within the law enforcement agency is a code of ethics, which is a statement of principles concerning the behavior of those who subscribe to the code. A code of ethics promotes professionalism, and it deals with responsibility, performance, discretion, use of force, confidentiality, integrity, cooperation, and conduct in one's private life. All right, to summarize this chapter, police can be held liable for monetary or other damages under 1. 42 U.S. Code Section 1983, and 2. State tort law. There are several defenses to each, including absolute and qualified immunity, public duty doctrine, contributory negligence, comparative negligence, assumption of risk, and sudden peril. External measures for police accountability include citizen oversight, citizen complaint procedures, agency accreditation, the exclusionary rule, and criminal prosecution. Accountability from inside police agencies is promoted by internal affairs divisions and professional codes of ethics. Okay, before I close, be sure to read the case on page 179 that deals with the attempted arrest of a fugitive with reporters accompanying the police when they served the arrest warrant and unfortunately dealt with the wrong parties. Well, that's it for now. We'll see you in class.